Morning, Judge.
Hey, what's going on with you?
How much are you? Right around.
Yeah, I want to go back to bed. Good morning, Mr. Salas. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You're also charged with evading arrest or detention. On that, you're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent.
All right, pause. This is the part most people don't understand. A probable cause hearing isn't the trial. Nobody's proving guilt here. The judge is basically asking, do we have enough to legally move forward today? And when the charges are DWI plus evading, the court is instantly looking at two things: danger to the public and whether this guy runs again. Keep your eye on how quickly this turns from what happened to what can the court actually prove.
Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On or about March 26, 2025, an officer was on patrol on Gulf Freeway in Harris County, Texas. The officer observed a motor vehicle disabled in the left hand with grass speed, dividing southbound and northbound lanes of traffic. The motor vehicle had multiple airbags deployed and all four tires appeared to be damaged. On arrival, the officer observed additional motor vehicle disabled on the open access roadway of what was formerly a car dealership. The officer observed the witness walking towards the officer, trying to get the officer's attention. The witness said that 5 minutes prior to the officer's arrival, the defendant approached the witness after the witness' tires were blown out. The witness informed the officer that the defendant demanded to use the witness's phone. The witness advised the officer that the defendant wanted to contact the defendant's mother to pick up the defendant from the scene. The witness told the officer that the defendant continued to approach aggressively and that the witness told the defendant the witness would call the police if the defendant did not stop. The witness said the defendant fled the scene on foot. The witness described the defendant's clothing, and the officer observed the individual matching the description running and approaching the scene of the incident. As the defendant approached the scene of the accident, the defendant began walking in a parking lot adjacent to the freeway. The officer gave loud verbal commands for the defendant to stop. The defendant fled on foot on the grass along a ditch. The defendant slid down a ditch and the defendant crossed Water Creek, then climbed the fence attached to a private residence, and fled on foot for approximately 0.4 miles before he was later detained by a Houston Police Department and turned over to deputies. The scene was moved to a Shell station to continue the investigation. The officers contacted the defendant. The officers observed a strong odor of alcoholic beverage emitting from the defendant, and the officers observed the defendant had red glossy eyes, slurred speech, dry mouth, repeating phrases, and agitated demeanor.
You say a shaky demeanor?
Sorry, agitated demeanor. And the defendant denied drinking alcohol and initially denied drug use, and then stated that he had been off for a couple of days and had consumed paste or coke. The officer, through training experience, knows this to be representing cocaine. The defendant admitted that he was going to a girl's house when the incident occurred and agreed to perform the standardized field sobriety tests. Those were administered, and the officer observed success exclusion on the HGN. The officer did not administer the walking tour of the one-leg stand due to the defendant injuring his feet while fleeing. The defendant consented to a breath sample, which was not completed due to interference being detected. The officer obtained a search warrant for the defendant's blood, and there was a blood draw.
This right here is the whole case. In DWI, the magic word is operation, not near the car, not owner of the car, not smells like alcohol. The state has to show he was operating, driving, controlling, or at least behind the wheel in a way that counts. And the defense just spotted a crack. Where's the proof he was driving? Because if the only solid facts are crash car plus guy nearby, that can get real shaky, real fast. What do you think? Does coming back to the scene basically admit it?
Okay. Your Honor, may I come?
Please.
I might have missed something, but besides the state saying that my client said he was going to someone's house, I didn't hear any operation facts.
I mean, he admits driving. He's by the car when the officers get there, right? Is he by the car when the officers get there, or where is he?
What I have, Your Honor, he has fled the scene when the officers get there, and then comes back to the scene.
Okay.
To the officers. The witness
Does the witness put him operating at all?
Yeah, just one moment, Your Honor.
Take your time.
Yeah, all I heard is going somewhere. It doesn't say he was driving anywhere.
They might refollow the part of the wrong corner. Sometimes they'll fade in, it's getting go.
I'm not sure, Your Honor, there was anything additional. This is kind of up in this mirror.
Hey, look at it.
See you again, Your Honor.
Yeah, what's up, man? Good to see you. Do you have anything else?
Your Honor, it does look like the witness stated that he stopped and exited his vehicle and observed the driver of the RAV4. That's what I have, but
So it doesn't match up with my plan.
Paris Urbana, Martinez stated once he stopped and exited the vehicle, he observed the driver of the RAV4, identified as Abraham Elias Salas, using driver's license, come out from the grass near the RAV4 and aggressively approach him, requesting to use his cell phone. Stated that he was trying to use his cell phone to call his mother to come pick him up, and that Salas said that RAV4 belonged to his mother. Martinez stated after a short time that Salas asked Martinez if he had papers for immigration.
Judge, even with these facts, it doesn't show driving. Even if he owned the car, we have no idea when. There's no facts to say that he was driving the car, that he admitted to driving the car. I don't see operations.
So Salas stated that he was driving the RAV4 because he was going to a female's house and continued to speak. Salas then stated that he ended up in the grass because he was scared. Then stated that he was a Mexican driver that swerved in front of him and allegedly
He said a Mexican driver swerved in front of him. Is that what he said?
told him no Tango Papeles or I don't have papers. Salas said the other driver was in a gray Toyota telling him to go away. Stated that the RAV4 and the alleged Toyota came into contact, causing a collision. Salas stated that he was coming from his house in Friendswood, but denied having anything to drink. So
Yeah, I mean, I think if they,
he was operating the vehicle at the time of the accident.
and you have the other person say something, right?
they say that it was, they identified him as the driver.
They just never say they saw him driving or operating the vehicle.
So I believe that they believe, based on the circumstance, that it was a driver. I don't know if the witness actually saw him driving. What we have to prove the driving facts is that Reeves fired to believe prior to his arrest. He admits that he was driving the vehicle at the time of the accident, and the vehicle was found at the scene of an accident. It was found nearby. Was observed coming out of the grass nearby. By the driver.
Although it's an admission, Judge, it needs to be an admission plus. I don't see that being enough for the plus.
Mr. Salas, I'm
there
going
it
to find
is.
that there's no
This is
probable
rare,
cause
it's
in
huge.
your
No
case.
probable cause.
Every
That doesn't mean
freaking
innocent.
day in our
It means
county,
the state didn't
someone
bring it up
dies from
today
an
to legally
alcohol-related
hold the case up
collision.
at this stage.
Don't
Think of it
become
like
a
the judge
statistic
saying,
because of a
"You might have a
boneheaded
case,
move
but you didn't
that
build
you
it right."
make.
And
where
notice
you
the
kill
warning
some-
he gives right
Do
after.
you understand?
Because even when a case collapses
Now,
on
I'm going to
paper,
find no
the
probable
judge is
cause. It's
still
very
thinking
possible
about the
they
real
go
world
indict
risk.
this case at a
Drunk
later time
driving
if they
kills
get more
people.
evidence.
Quick
But
question.
don't
Should courts
kill
dismiss weak
anyone.
cases even
Do
if
you
the
understand?
conduct looks
Yes, Your Honor.
obvious?
see.
Thank you, Your Honor. Are there any conditions you're imposing on the evading case?
No, I'm going to find no on both.
On both. Thank you, Judge.
Talk to me.
Desnick Smith. He's one of the ones that,
Yeah, ones, okay. What's the last name?
Smith, Desnick, did you do? Out of Louisiana, one of those four guys that you already talked about. He's the one that did not have he was a passenger, not the one with the weapon.
There were 3 passengers.
I talked to his mother.
How old is this kid?
He's awfully young. I can't, he's got a computer, I don't. He looks awful young. I talked to his mother. His mother's willing to post bond and able to post bond if it's reasonable.
Therein lies the question. What is reasonable? Right.
1,500 would be reasonable.
He's coming back in.
I know. Nelson, did they respond?
What's that?
Did they respond on Nelson?
Smith, may bring up Mr. Smith.
Okay, yeah, we're on Smith.
Okay.
Smith's coming out now.
Plaque claims that they told them they were not going to mess with it. But we'll still wait for the official word from Florida. What's that name of that city?
I don't know that, I just went by the county.
It's another one of those.
I've been mispronouncing,
Natchitoches.
I've been mispronouncing
I
county.
know.
Morning, Mr. Smith. How's jail?
The worst experience of my life, bro.
Makes me really happy. It's supposed to be, you know? The idea of jails are that you learn. And unfortunately, we have people that just don't get it. No matter how long the sentences are, no matter how cold the bars get, they just don't get it. You're wanted out of Louisiana for this, this car.
Yes, sir.
Your lawyer's asking for me to set you a bond, but I don't know. I've never met you before. I don't know you. You know, one of the things that I consider is, number one, are you going to go back if we set you a bond? Number two, are you a dangerous person? Because I don't want to set you a bond and then you leave a wake of destruction on your way to Louisiana. I mean, I don't want that.
Yes, sir.
So, Mr. Kim, tell me about Mr. Smith.
Your Honor, this now defendant, along with 3 co-defendants, stole a vehicle out of Louisiana and transferred state lines on the same day and was apprehended in Harris County. He's facing a felony charge there due to the fact that they transferred state lines within 24 hours of stealing the vehicle, which was captured on surveillance video. State would be opposed to a bond as state considers him a flight risk.
Now we've switched genres. This is out-of-state fugitive territory. And bond here isn't really about punishment. It's about one thing. Will he actually go back to Louisiana? Because if the court lets you out and you vanish, that becomes a nationwide headache. Also, listen for the judge's pattern. He's not just reading charges, he's reading people, family support, transportation, ties to the area. That stuff matters more than viewers realize. Would you set bond if the person has 0 ties here?
Any prior criminal history?
No, Your Honor.
Judge, he is from Natchitoches, Louisiana, which is where the offense is from. His family lived there and he was born there. They moved to Manning, Louisiana. I talked to his wife and his girlfriend.
His wife?
Mother.
23.
That's what I
His
call it.
mother and his girlfriend. Okay. I spoke to his mother, Sophia Smith. She lives in Manning, Louisiana. She will post his bond. And I spoke to Sophia Smith and she'll come over and pick him up. That's and transport him back to Louisiana.
Here's the thing, Mr. Smith, is I need you to understand that we don't play games. If I set you a bond and you make that bond, we give you 2 weeks to go turn yourself in.
I will, sir. I promise.
We don't play games. So if you fail to do it, I'm going to revoke that bond. I'll set it at 0. I'm going to issue a nationwide warrant for your arrest. I'm going to get you because you can't run forever. And the next time you will not get another one. Do you understand? Okay. I'm going to set you a bond at $1,500. Here's the other thing. Life is short. Life, when you end up with a bunch of convictions, it doesn't become a fun life. What makes life fun is you get knowledge. And when you get knowledge, you buy things because you get money. But you only do that when you go out there, school, learn, get a good job. That's what life is about. I'm not picking up convictions.
Sir, that's nothing. I'm in college right now too, sir. That's why it's kind of creative. I'm
Really in college?
for audio arts.
And now with all this, really? Dude, when you hang with boneheads, it doesn't end up well, you know? Get a clue so you don't end up back here. Mr. Smith, I'm going to set your bond at $1,500. Just, Mr. Smith,
Yes, sir.
don't disappoint us, man. Do something with your life. Don't become another statistic. $1,500 and then do right, man. It's not hard in this life, you know?
Oh,
All right, we got you, buddy.
Thank you, Judge.
So if he can make it, I'll print out the reset for him to sign and I have the waiver withdrawal for you to sign. 'Cause he's-
I'll read that. Don't send him back yet. You got some.
Yeah, so I'm typing up the reset right now, but the waiver withdrawal is there for you to sign.
You're Jeffrey Chauvin.
Yes, sir.
Mr. Chauvin, you're charged with criminal trespass. You're also charged with resisting arrest. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay, please.
On March 5th, 2025, an officer was dispatched to a trespasser call at a Whataburger in Harris County, Texas. Complaining witness, an employee, stated that she told the defendant who was in their dumpster in the parking lot to leave, and the defendant refused. Staff tried to tell the defendant to leave again at 1 a.m. and defendant stated that he would leave in an hour. At 2 a.m. and 3 a.m., defendant was still refusing to leave after being asked to do so multiple times. At 5 a.m., the trash company came. Defendant refused to come out, so they could not pick up the trash. The officer observed defendant in the dumpster and asked him multiple times to come out and that he had been trespassed from the location, but defendant continued to refuse for about 30 minutes. The officer asked the defendant if he would be willing to go to the jail diversion center, and the defendant said yes. The officer handcuffed the defendant so he could eat food. Officers provided him. The officer went to reapply handcuffs, but the defendant resisted passively by not following officer commands to lean forward. The defendant verbally stated, "No, I'm going to keep my hands here." After several attempts and the defendant not following verbal commands, the officers removed the defendant from the vehicle and put him on the ground so he would not hit his head. While officers attempted to handcuff the defendant actively resisted by pulling his arms away from officers. The officers still took the defendant to the jail diversion center, but upon arrival, the defendant said he did not want to be there and just wanted to be released, so he was rejected. While en route, the defendant had taken his seatbelt off, put his handcuffs in front of his body. The officers told the defendant he would have to be handcuffed behind his back, and the defendant agreed. Officers told the defendant to lean forward, and the defendant stated, "No, you're going to have to shoot me," and actively resisted by pushing his body onto the officers in an attempt to escape from the patrol vehicle. The defendant stated he would stop resisting once officers loosened up control, and when officers did, he would go back to actively resisting by attempting to get out. The officer was eventually able to secure the defendant. The defendant broke the officer's nail on the right hand, and officers sustained minor bruises to his finger and forearm.
I'm charged with the assault on a peace officer, Mr. Chauvin. I'm going to find that there's sufficient probable cause to go forward with the case.
This is one of those moments that hits different. The guy says he was homeless, sleeping in a dumpster, and the judge immediately shuts him down, not to be cruel, but because anything he says can hurt his case. That's real courtroom strategy. Also, notice the judge mentions second PR, bond. PR bonds are basically trust-based release. But the court keeps receipts, miss again, and that trust account is closed. Real talk. Should homelessness change how trespass cases are handled? Or does the law have to stay the law?
Do not go back to this Whataburger. Do not go back to this Whataburger. Do not pick up any new cases and show up to court. When you show up to court, good things happen. If you take off again, it's not going to go well. We've already given you, this is your second PR bond. Do you understand?
Yes, sir. I was not told I had court the first time. I was homeless. I was sleeping in a dumpster.
Okay, well, I don't want you to say anything now because I don't want you to hurt yourself. Let me give you a lawyer. They'll be able to talk to the lawyer how to resolve this case. Just, we're going to give you a future court date, most probably. If you miss it again, I'm going to issue a warrant. You're not going to get a third PR bond. Do you understand?
I have to remain in Houston until this.
Well, let me get you a lawyer. We can talk and try to see how we go forward. For now, let me just have you go to Victoria, sign a reset. I'm going to have you take a seat in the jury box, and then we're going to get you a lawyer here momentarily. Okay? Please. Are you Alfredo Gutierrez?
Sure.
Mr. Gutierrez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. As you can see, your lawyer is here with you, not in person, but on Zoom, so that you're not here alone. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay. Please.
Right, just one moment. I'm sorry, it's moved also small.
Okay, no problem. Oh, I see you're also charged with unlawful carrying of a weapon. And in that case, you're facing up to a year in jail and or a $4,000 fine. Okay.
March 25th, 2025, in Harris County, Texas, a law enforcement officer responded to a single vehicle accident and made contact with the defendant, who stated that he was just being stupid and spun out and hit a pole. The law enforcement officer observed the defendant to have bloodshot eyes and a mild odor of alcoholic beverages emitting from his person. The defendant admitted to drinking one beer. Standardized blood sobriety tests were conducted, and the law enforcement officer observed 6 out of 6 on the HGN test, 3 out of 4 on the one-leg stand, and 3 out of 8 on walk and turn. The defendant consented to a breath specimen and blew .078 and .074. Law enforcement officers also found a loaded handgun in the center console of the vehicle.
Okay. Any prior DWIs?
No, Your Honor.
You've run his NCIC?
Yes, Your Honor.
Driver's license?
Still.
Please.
Sorry.
Mr. Gutierrez, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand? As long as you have a valid license and liability insurance in your name, then you may continue to drive. If you don't have either, then you're not allowed to drive, and that is also a condition of your bond.
Correct.
Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. Davila and he'll tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're playing games or you're ducking and dodging phone calls, I will issue a warrant for your arrest. Don't pick up any new cases. I'll have you go to Victoria Center reset. You'll get with Fleischer for your bond conditions and then you're free to go.
Thank you.
All right.
All right, Judge, how's June 3rd or the 5th?
You hear that, Ray?
June 5th, please.
Okay.
Okay, man. Have fun.
Thank you, guys. Bye-bye.
Take care. You are Mr. Scott Sanders. Mr. Sanders, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On March 25th, 2025, officers initiated a subject stop at a Walgreens on East Mount Houston Road, Harris County, Texas. Officers observed the defendant sitting outside the entry holding a brown cardboard sign, panhandling. Officers approached the defendant. Defendant stated, "Okay, I'm leaving. I'm leaving. They told me to leave. I'm leaving. Don't take me to jail." Officers asked consent to pat down the defendant. The defendant consented to the pat down. The officers observed a green leafy substance in a plastic bag located on defendant's person. Defendant stated he forgot the marijuana was there, but that it was only kush. Officers observed an additional plastic bag containing a green leafy substance. The officers observed the marijuana to weigh 0.045 ounces. The complaining witness was identified by their Texas driver's license and advised that the defendant has shoplifted multiple times and has been trespassed. Complaining witness informed the officers that complaining witness asked the defendant to leave prior to the officer's arrival. Complaining witness advised officers the defendant initially left the property. Complaining was unaware of the defendant's return to the store until the officers contacted him outside the store. Officers note defendant's theft case was against that Walgreens and was dismissed. Officers notes that the defendant has been criminally trespassed from the same Walgreens. Officers also noted that they did observe a meth or crack pipe on the defendant's person. The complainant was able to identify the defendant based on the previous mugshot.
Mr. Sanders, I'm going to find that there's sufficient probable cause to go forward with your case.
Yes,
Let me provide you a lawyer today so that you can talk to someone about this case. All right. For now, do not go back to this Walgreens. Let's not talk about this case because you have the right to remain silent. I don't want you to say something that hurts your case.
I want to say something about seeking treatment.
Okay. Let me get you a lawyer first and then we can talk about it and we'll try to help you as much as we can. Okay. Vic, do you mind?
Yes, Judge.
Okay. I'm going to have you sign a receipt with Victoria and then we'll have you take your seat in the jury box, sir. Okay.
Right this way. Go ahead and sign for your receipt, please. Right, Judge is page 32. Williams, come on up.
Good morning, Mr. Williams. Sir, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Okay. On March 25th, 2025, an officer was dispatched to Montrose Boulevard for a call for service related to driving while intoxicated. The officers observed the defendant's motor vehicle upon arrival. The officers observed the defendant's vehicle to have major front end damage, multiple airbags deployed, and to be leaking fluid. The officer met with the witness who called 911. The witness stated he observed the defendant's vehicle to have struck a light pole. The witness stated that he did not see the actual crash, but saw the defendant back up and start driving away from the crash. The witness observed the defendant drive several hundred feet before stopping due to the motor vehicle being disabled. The witness stated that they observed, the officer made contact with the defendant, and an officer observed a strong odor of alcoholic beverages emitting from the defendant's person. The officer also observed the defendant had bloodshot eyes and slurred speech. The officer observed the defendant had trouble maintaining balance as well. The defendant consented to standardized field sobriety test. The officer observed 6 out of 6 clues on the HGN test, 7 out of 8 on the walk and turn, and 4 out of 4 on the one-leg stand. Defendant consented to a breath sample, and which the test readings came back at 0.185 and 0.168.
Any prior DWIs? And then does he have a license?
No prior DWIs, Your Honor, and I'm running that license.
Please. Mr. Williams, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will revoke your bond and put you in jail.
His license is eligible. No.
As long as you have a valid license and liability insurance in your name, then you may continue to drive. But if I find that you're using, it's not going to go well and I will revoke your bond and put you in jail. Do you understand? Do you have the ability to hire a lawyer, sir? Okay, we will give you time to hire a lawyer. So I will first have you go to Victoria, sign a reset. You will then get with Fleischer for your bond conditions. After that, we'll get you out here to hire a lawyer. All right? Please.
This way.
Good morning, Ms. Woods. Ma'am, you are charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
On March 26, 2025, in Harris County, Texas, officer was dispatched to a disturbance call. Officer met with the complaining witness who stated that he and the defendant were in a sexual relationship. Complaining witness stated that he and the defendant got into an argument over the Wi-Fi password. The defendant punched the complaining witness in the face, head, causing pain. The defendant also ripped the complaining witness's shirt, scratching him in the process, also causing pain. Officer observed the defendant to have visible injuries to his face and back.
Do we know whether he wants to have contact?
No, it's not.
He does not want
He
to.
does not.
Okay. Ms. Woods, I'm going to find that there's sufficient probable cause to go forward with the case. A protective order has been issued in this case. I would get to know it. If you do something to violate the protective order, the state can and probably will file a violation of protective order against you. It's one of the worst cases you can pick up. I am ordering you now as a condition of your bond not to have any contact with this person and not to be in possession of weapons. If you violate this, we will revoke your bond and put you in jail. Do you understand me? Do you have the ability to hire a lawyer? We can have you fill out an application. I'll take a look to see whether you qualify. Deputy Miranda is going to give you an application. I need to know everything about you, where you work, what kind of money you make, money in the bank, car, what kind of car you drive. And then I'll take a look to see whether you qualify. I'll have you sign a receipt with Victoria. We'll give you the application, then we'll have you take your seat in the jury box. Thanks.
This way.
And they're dismissing the felony upstairs, and he's
Change for
doing,
this?
yes, for the probation with TRAS conditions.
Has a TRAS been done yet?
Yes, and the recommended IOP is
Solustria.
No, shh. You have, or you're not you, but your lawyers have worked a killer deal for you today. You speak English, right?
Yes, I do.
Where they're going to dismiss the felony in exchange for your plea on this case. I'm going to tell you now, this is not something that happens very often. So get a clue. Do you understand?
Yes.
The agreement that you have worked out here is you're now charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. The agreement that you have is 180 days in jail to be probated for 15 months. You need to understand that this charge is going to go on your record. It will be there for the rest of your life. From now on, you're facing a minimum of 30 days in jail for any new cases that you pick up. Not only that, whenever you get pulled over, officers, the first thing they do, and the only thing they do when you get pulled over is they look at your record. If they see that you have a prior DWI, if they see that you have a prior felony PCS, you think they're going to treat you good if they smell anything funky? Probably not. So don't give them the ammo to shoot you with a gun. It is a DW, any prior DWIs? So the agreement is a DWI education class, 1 victim impact panel, a TRAS, but you have already done it. So the TRAS here is recommending intensive outpatient treatment followed by supportive outpatient treatment. This is what you must do. If you fail to complete these conditions, I will issue a warrant for your arrest. I will put you in jail and I'm going to bring you right back out in orange and we're going to talk about whether you violated. And if you did, if you do, you're looking at 180 days in jail. Do you understand? No drugs, alcohol, random testing, and a guardian and a lock.
He has, we're going to do the portable because he's not driving, doesn't have a license.
So be signing an affidavit today promising us you're not going to drive. Mr. Garcia, do not drive. If you want to see me grow horns and a tail, I'm telling you, don't drive. If you want to drive, do things the right way, ask for permission, get a license, get insurance, and then I will be dancing happily because you're doing things the right way. But if you go out and you do it on your own and you're not licensed, I'm going to lose it. You understand? All right. You're giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I will send you to this agreement. Good luck to you, sir.
Thank you very much, Judge.
Judge, we have a,
Mr. Garcia?
no, no,
Okay, all right. Good luck, sir.
on Mr. Sullivan, I have Mr. Dixon. For Sullivan, there was a PC.
On Ms. Loyola, this is the young lady that a few days ago you took into custody because she picked up a new case while she was out on our bond.
Right, okay.
She had the felony case. The felony's reset. She's here for her, I guess, arraignment on the new bond. But I think you had already modified her bond conditions 2 days ago. So,
Come up, Ms. Loyola.
we do need to talk about some driving issues though, Judge. So I'll
She doesn't have a license. That's the issue. If I remember correctly, right?
I think you do have a license.
I was working on getting it fixed. It was, not an edit.
You don't have a license and liability insurance in your name, don't drive. It's as easy as that. If you get your license, then we can talk. But until that point, I don't care what you have to do. I don't care what baby needs picking up. I don't care. You cannot justify getting into a car and driving unless you have a Texas driver's license and liability insurance in your name.
I was
You-
working on getting it.
Okay, working on it doesn't mean that you get to drive because you're working on it. No driving until you have a license in your possession. If I find that you do, I can have a contempt hearing, and every time you drive hereforth, it's up to 6 months in jail and a $500 fine. If you pick up a fourth case, I'm going to lose it. Do you understand? All I'm asking you to do is follow the law. I'm not asking you to do Pythagorean's theorem. Okay, we'll give you a normal setting. Well, actually, no, we won't. The assault's at nearly 200 days now. Is this your case, Sebastian?
Yes, it is. I just,
Discovery complete?
I believe it is, Judge. I'm trusting.
Judge, it's the problem is it's the same transaction out of the felony court, out of the felony case. So I've tried to reach out to her felony attorneys. She tells me that it's bad communication with that particular person. So I'll have to try to really hard to find out because she's hoping
Right
that
here.
Yes.
Mr. Gould, Mr. Gold was here. That's the lawyer.
Yeah, I saw him today.
Did you speak to him? And does he know the,
Yeah.
okay, so I guess he knows the situation.
I tell you right now, Judge, I just. As far as the assault, the only thing is that there's some CPS records. I still don't know if the case is closed because obviously they don't give it to us until the case is closed. But apart from that,
I mean, does that really come in this case anyways?
it can. There, I mean, so typically the things that would be in there is typically they do an interview with defendant, they do an interview with kids.
I mean, unless it's relevant, I don't know, but.
Yeah.
I
mean, but you are right. I mean, it is a case by case basis.
Can you tell me when that felony's reset to?
Felony is reset to the 21st.
And is there an offer in the felony case?
I believe the note is. I mean, essentially the offer upstairs is that if she takes something on the misdemeanor, then we'll get rid of the felony.
Okay, so they're set for 4/21. I'll give you the same day after the day it's clear trial here.
Gotcha, 421, Judge?
21, right?
Is there any
I would
way
imagine that's probably a global offer for everything.
Can we go 422?
Sure.
Okay.
But then she'd be coming that day and then the next day. She's on bond.
Right, I got you.
up to you.
But hopefully I'll talk to her. If we can get the deal together, then I might just bring her back before then to get it done.
Okay, but after that setting goes clear trial.
I got you.
Got it. All right, John.
Thank you, Judge.
Leaves you are charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Has probable cause has already been found on this, right?
Yes, Your Honor. So she, it's already been found, but this case is really old. She didn't come to court. So this is kind of, she got rearrested for the same charge.
Okay. Where's this from? If you don't mind.
Your Honor, I'm sorry, I did just.
Needs.
Eames?
Need, N,
Yeah, thank you.
N-I-E.
Your Honor, the offense date was October 11th, 2023.
Where from though? With that word.
Oh, where? I apologize.
Walmart.
It was Walmart, Your Honor.
Okay, can you look to see if discovery is complete?
Yes, Your Honor. It does look to be complete, although we'd have to talk about the videos. Yes.
Well, just to get this case, because they already had a prior PTI offer, which you're supposed to do an anti-theft course. They just reinstated the offers. They said that they'll still take the offer.
They said that they're going to keep the offer?
I spoke to them this morning.
Okay.
So she's going to complete this class this week, and I'm going to send it to them for dismissal.
Okay, this case is 1,269 days old. I'm now putting a monitor on your ankle so I know where you are at all times. You have 2 weeks to get this class done. If you don't, I'm going to set your case for trial. Do you understand? You get no more resets after that.
Okay.
Okay, all right.
Thank you, Your Honor.
So Felicia, if she can get today, please. You are Mr. Vasquez Lechado.
Yes.
So you're charged with driving while intoxicated, facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement where they're offering you 21 days in jail with credit for the 7 days that you have done. You're pleading guilty to this offense and it is now going on your record. You need to understand that from now on, facing a minimum of 30 days in jail for any new cases that you pick up. If you ever get pulled over from now on, officers will look at your record, they'll see a prior DWI. If they smell alcohol or dope on you, it's probably not going to go well. So from now on, I would never, even if you have a sip of alcohol, don't get into a car and drive. It's probably not going to go well for you. You're giving up a lot of rights by entering into this agreement. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty, it goes on your record. It'll be there forever. Is this what you want to do?
Yes.
You plead to the offense guilty or not guilty?
Guilty?
I'm going to find you guilty. I will follow the agreement, send you to it. I'm now going to suspend your ability to get a driver's license for 90 days. Do not drive until you get a license. And good luck to you, sir. Thank you.
And Your Honor, if I may mention, well, I did want to mention something else, Your Honor. This was a case that I was appointed to maybe like 2 days ago. I did speak to Mr. Vasquez to let him know that's not all the evidence is in, and that he does have the right to that. He has been in custody since January. He got transferred to ICE, which he says he no longer.
So you need to understand that not all the evidence is in this case. By getting all the evidence, it's very possible that she may have a chance to fight your case and beat it. Once you plead guilty, there's no turning around. You cannot come back and return this like you don't like it from Target. Do you understand? Do you want more time to fight the case or do you want to continue with this plea?
I'm fine like this.
Okay. All right, I'll make a documentation that
Thank you, Your Honor. I appreciate that.
it's against your.
Yes, Your Honor.
All right, come on up.
How you doing? Hey, Judge, good morning. This is Mr. Dalen Calhoun, Judge.
I'll sign this real quick.
Don't say anything about the case, okay?
All right.
Use the focus of getting to the proper place to handle your business.
Who?
That's right. That's right. I was so confused. Scott Sanders?
Okay, What is his name?
His name is Jalen Calhoun.
Good morning, Mr. Calhoun.
Good morning, what you doing?
So it seems that you are one of 4 co-defendants that we have on a case arising out of another state.
Yes, sir.
You are wanted out of,
Louisiana, Natchitoches Parish. I butchered the pronunciation, but.
Natchitoches.
Yes,
What is it?
Natchitoches.
That.
Louisiana.
Lawyer is asking me to set you a bond, but I don't know. I don't know you. I've never met you before, and I have a very short amount of time to get to know you to see what kind of person you are.
Right.
Paper really tells me who you are. The words coming out of your mouth, I just right. So, tell us about Mr. Calhoun.
Your Honor, he's wanted out of Louisiana for transfer and possession of stolen vehicles, not equivalent to theft of a motor vehicle, and him and 3 other individuals, one whom is charged with UUMV, were found same day where they stole a vehicle. We have a parallel charge with Louisiana where they're charging him for the theft, and we have for the driver.
But the thing about it is, I wasn't there.
Don't you really think that you can just start spitting out something? Where do you think you are? Really?
My bad.
You think that this is helping you, Mr. Calhoun?
Sir.
You're not at home. You're not on the street. Okay. Please.
Your Honor, the same day that they stole the vehicle, which was captured on surveillance off campus, they transversed state lines and came to Texas, and they were found in Harris County with obviously traffic infraction being the probable cause, and found with all 4 occupants of the vehicle. The fact that they transversed state lines, they would be opposed to a bond. There was also, and because I took a charge, I know before the office reports out, is that there was also a firearm found on one of the passengers and that they were trying to conceal. At the time, the officers were getting everybody removed from the vehicle, and obviously 2 of them being under the age of 21. So they would be opposed to a bond for.
So hold on a second.
Yes, Judge.
It's a stolen car.
Yes, Judge.
Out of Louisiana.
Yes, Judge.
They come to Houston.
Yes.
All 4 of them.
Yes.
How do we know the other ones knew that it was stolen? Do we have any kind of?
In Louisiana, and they did it in real time. And the complainant stated none of the occupants in the vehicle had permission to take the vehicle.
I know that.
Oh,
But how do we know that they knew that it was stolen? Right? So what if I come pick you up in my car?
Oh,
it's
I
a
see
stolen
what you're
car.
saying.
You have
So-
no idea it's stolen.
I see.
Like if everything's ripped off in the inside, you got like, there's a screwdriver for the steering wheel, and the steering column's been ripped off. Then there's facts that lead you to believe that it's a stolen car.
So for running the plate because it was reported stolen, and the fact that it was, well, at the time of I'm sorry?
That's still.
No, again, on surveillance video in Louisiana, that they have it in Louisiana, that these are the original individuals that stole the vehicle. That's how they knew, that's how the officers in Harris and the officers in Louisiana knew that they knew it was stolen because they were the ones who stole it.
They have them, you saying on video?
Yes, that's what
All
I'm
4
trying to.
together is taken.
Yes, that's what I'm
Yeah,
trying
well,
to.
that's something.
Can we see
different.
this video? I haven't seen this video. It's
You're not gonna get to see the video. That's what the
That's in
underlying criminal
Louisiana.
case.
well, you're basing your decision on a video that the prosecution says he saw, you haven't seen, I haven't seen.
I just want to know how they impute the thievery to him.
Correct.
And he's saying that
they're
there's a
because of a
video.
surveillance video.
And the Louisiana officers were telling the Harris County deputies that they have it on surveillance video. That's how.
Specifically what? Where was my client? Was he the one?
We're not gonna get all that.
Right, but we're talking about that.
Our criminal history?
No, Your Honor. This is based on flight risk. They literally transverse lines the same day they stole a car.
It hasn't been proven that he knew it was stolen.
How many got charged with the UUMV?
The driver, because that was the only.
That's the only one.
Driver, right.
So your position on bond is what?
There's no bond because of the flight risk. They literally fled the same day within 24 hours, really 24 hours within stealing a car. Judge. They literally fled the state.
They keep
stealing
saying
a car.
they stole the car. He didn't get charged with stealing the car. He's not in the vehicle. He is charged with transfer.
No.
He
He is charged
he is being
in
charged.
Louisiana.
Well, then that's a,
He is charged, but in Louisiana.
okay, well, he's
Here,
being charged with
he's being
that.
charged
Just
with
because
it.
he's charged with it doesn't mean you're going to convict him. I see like very good arguments as to why he shouldn't be convicted. Secondly, if we're talking about flight risk, he was a passenger. He hasn't had the opportunity. Where was he going? Did he know he was fleeing the jurisdiction? He doesn't know that It's stolen, like you said, is the steering column broken? Okay, at that point, perfect. He should have known. There's nothing to say that that's what happened in this case. We're assuming the worst, let's assume the best. He's presumed innocent. Let's not assume that he knew he was committing a crime. Let's presume he was innocent. So in that case, let's give him a bond. Let's allow him to go and fight this case. He can't fight it here. He's fighting an allegation that we don't have, the surveillance video that we haven't seen. Let him go fight the case over there.
21, sir.
I still stand on no bond.
I mean, I'm
Regarding the flight risk, and so.
Well, you got to understand, in life, there are consequences to action, right? When you hang out with dogs, you get fleas. I can set you a bond, but you need to understand from the time that you're released, we give you 2 weeks from the date of that release to go turn yourself in to that parish in Louisiana. If you fail to do that, I will revoke the bond that I'm going to set here. I'll set it at 0. I will not give you another one. You can't run forever. At some point, we'll get you. And then that time, when we do get you, I will physically hold you until Louisiana comes and gets you. Do you understand?
So if I go down there, I'm at the bond down there 2 months.
That's correct.
Right. The thing is that I will probably set a bond around $5,000. You'll probably have to make all of it because you are a flight risk. You're wanted out of another state. If you waived yesterday, we have buses coming in and out of Louisiana about 2 times a week. So if you keep the waiver, you'll probably be back Wednesday. At the latest, Monday, you'll be back in Louisiana Monday-ish, where if you want to bond out, you can, but you're going to have to make it on your own to Louisiana. And then you'll have to bond out. Or no, you're going to have to turn yourself in over there. You can't bond out. Is there no bond set?
I believe it's no bond. I'll double check.
You'll have to turn yourself in there. So if you want me to set a bond, you have to withdraw your waiver and you're going to lose the credit that you've built up toward them. Because if Louisiana doesn't come get you here within 14 days, we release you regardless. And then you don't pay anything. You're going to get released. So I'll let you talk with Ricardo and make the decision what you want to do.
Yes, sir.
What amount would you be thinking, Judge?
5,000.
5,000? Judge, he is 21 years old.
Yes, sir.
He would be seeking the support of his parents. It would be a bond that he's got to post 100% on. Would you consider going to 2,500? No? Okay, fair enough. I'll talk to my
You
client.
could even get a bond, Mr. Calhoun, really. And I don't even know if I'm going to do the other ones as well, I mean, I don't know.
I'll
So
talk to my client, Judge. Thank
Okay.
you. Appreciate it.
I'll just read you the PC summary again. So on March 23rd, 2025, in Harris County, Texas, officer was dispatched to a disturbance call and met with the complainant witness, stated that the defendant is her husband. The complainant witness stated that she told the defendant that she was going to move back to Arizona that day, and they got into an argument. The defendant then told the complainant witness to hit him in the face. The complainant witness then struck him in the face 3 times.
right.
The complainant witness then stated 10 minutes later, she went into the bedroom where the defendant then laid down on top of her, grabbing her wrists, causing pain.
Oh, that's 10 minutes later.
That's 10 minutes later. Grabbing her wrist, causing pain. Complainant witness then got one arm loose, grabbed the defendant's genitals, causing him to let go. And then the defendant then struck the complainant witness in the mouth, causing pain. And the officer observed the complainant witness to have bruises on her arms and injuries to her top and bottom lip.
How is it?
I think we are omitting some things that's pertinent to the decision that you're going to make.
What?
That she asked, her daughter told her that you have to make a choice between.
Oh, that's right. Yeah. I remember. And then she makes a choice of him.
And she said, I'm leaving you and I'm going to be with my daughter and grandchild. And then he comes and tell her, if you're really that mad at me, then hit me. And that's when she went to him and hit him twice. Boom, boom.
How is it fair that I find probable cause on him and not on her? Why didn't they charge her?
So I would say one is the fact that he quite literally says to hit her or to hit him.
Can't consent to an offense, Judge. If he tells me to shoot me.
Yeah, no. I mean, you can, like, boxers consent to assault, right?
That's.
But I mean, in this.
I think where we are for PC purposes, as far as this offense goes, is that it occurs 10 minutes later. Then we have essentially in a situation where he can't essentially claim self-defense if he's the one being the aggressor first, where he's grabbing her, 10 minutes after this kind of initial incident happened, he's grabbing her, then she grabs his genitals, and then he punches her in the face. I think that's where we're at as far as PC goes.
I don't think that's the law, Judge. I don't think you can avoid what had happened earlier just because it was 10 minutes later. I don't think you can take the fact away that she was the one that instigated and was the culprit of the initial assault.
But there's a long cooling down period.
Okay, this exchange is spicy because now we're in a legal gray zone argument. He told her to hit him, so can he complain later? The lawyer is basically pushing consent and self-defense logic, and the judge is pushing back with the common sense version. You can't consent your way out of serious harm, and the timeline matters. 10 minutes later becomes the entire battlefield. Cooling off period. Who was the aggressor? What's self-defense? What's retaliation? Drop your take. If someone says, hit me, and you do, should that ever turn into charges later?
You know, if it's like maybe a minute or two after the fact.
I would say.
And then, but nevertheless, though, how's it fair that she's not charged? I mean, why does she get the benefit of the doubt? Because she's wearing a skirt.
I mean, the code does say you can consent to an assault.
If you consent to, if you tell me to shoot you and I kill you, you don't think the cop's gonna get me for murder?
Well, you can't consent if there's serious bodily injury involved. You can't consent if there's no threat or actual serious.
Come up, Mr. Sullivan.
Less than the serious.
I mean, an assault does occur in this case with him and her, but there's also another one that occurs, you know, so.
I would argue, Doug, that at this point, with the charge that we have, that's going to be fact issues that I'm sure we're going to parse through moving forward, but I think that's.
And I think it'll work to the benefit, you know, so Mr. Sullivan, I'm going to find that there's sufficient probable cause to go forward with your case. Don't have any contact with this person, please. The only thing I'm going to ask you to do is don't pick up any new cases, don't have contact, and don't be possessing weapons. I don't know why they didn't charge the other person. I don't understand. And I don't know. But be it as it may, just don't have contact with this person. I think that, you know, it's just could be like a rumbling volcano. And the last thing we want to do is we don't want anything more to erupt. We don't want further charges and just, you know, and I think that, you know, they'll take it into account when you guys are talking about this case, but just stay away. That's all I'm asking you to do. Okay.
Well, Judge, with all due respect, I don't think it's too late to not to file charges against that person. I mean, I've seen cases where there are 5 charges.
That's not me. That's up to the DA's office and intake whether they.
Then I think the DA's office should take that in advisement to file charges against the person who was the actual initiator of the contact between these parties. If they do it all the time, I've seen cases where the district attorney filed cases 1 year later, when they know that there's evidence to substantiate the filing of a charge against somebody.
Who knows? Maybe it will. I don't know. Do you mind filing no contact, no weapons? I've given you a lawyer. All you'd have to do is just stay in contact with Mr. Dixon. He'll tell you if and when you have to come back to court. I'm going to waive your appearance so you don't have to waste your time coming to court. Just stay in contact with him and he'll tell you if and when you have to come back. Don't leave until you sign the bond conditions. Once you sign them, you're free to go.
If I run out, if I get put some money.
Go. Take your time. Just come back.
Okay, I will. Thank you. Thank you.
Take care, sir. Great. This gentleman with you.
He is co-defendant with the other one, Your Honor. If I may, I'll wait. So I heard everything y'all said. You want to go first before I start my spiel here? Which co-defendant?
Oh, yeah. What's the last name?
This is Doty.
Doty?
This is Doty, D-O-T-Y.
So, Mr. Doty, you're wanted out of the state of Louisiana for a particular charge. I think it's like a theft or whatnot of a car. Your lawyer, are you asking for a bond? Your lawyer's asking me to set you a bond, but I don't know. I've never met you before. I don't know anything about you. The way I get to know you is how you look on paper, because that really tells me who you are, whether to grant you a bond or not. The good news for you is that if it doesn't happen, we have so many buses coming in and out of Louisiana into Harris County, because we have a lot of Louisiana people here, that I'd say might be once, at least once, if not twice a week, there are buses coming in and out of here, shuttling people to and from Louisiana. Mr. Kim.
Your Honor, same as the previous approach, is that this is one of 4 occupants of the vehicle of a vehicle that was stolen earlier that day in Louisiana, and they transversed the state lines, being apprehended in Harris County. State would be opposed to a bond due to flight risk of transversing state lines. The same day they stole the vehicle, felony out of Louisiana, where they were captured on surveillance video.
Any criminal history?
No, Your Honor. If I may, Your Honor, he has no ties here. He lives in Natchitoches County, okay, parish, I'm sorry. He worked, his address is 500 North Street, apartment, what did I say?
A4.
A4?
H.
H4, Louisiana, zip code 71457. He lives there with his mother, Cynthia. He, 2023, got his GD from a program there called Ben Johnson. He also works at Pilgrim's Pride, which is a chicken plant. And so why are we holding him and paying him to pick him up? I would ask for general order bond, and he's going back to Louisiana. He's not staying here. That's where he lives. That's where he resides. And he can go post bond, get his lawyer, and deal with it. If he was charged with this in Harris County, this would be a criminal trespass. He's not the driver. The driver's charged in the 177th for unauthorized use of a motor vehicle. So if the appropriate charge in Harris County, if they had even been charged in Harris County, would have been a misdemeanor trespass.
I'm not going to give him a PR bond. I mean, he's a fugitive wanted from another state.
Well, he's an 18-year-old kid. I would ask if you would go lower than.
You need to understand, Mr. Doty, that actions have serious consequences. You're only 18. Are you 18? How old are you? 18. You're just now starting your life. And when you hang with dogs, you get fleas. We have enough people in there now that become statistics all they do is they end up running with the wrong crowd, end up with convictions, and essentially ruining their life. Once you become a convicted felon, it becomes extremely difficult to get a job, to get any kind of position of trust. People don't trust convicted felons. You don't get a good job when you're a convicted felon because no one trusts you. They're always going to think in the back of mind, okay, is this guy going to steal from me? Is this guy going to do this to me? Is he going to? You're on the road fast with what's happening now. Your lawyer wants me to give you a very low or free bond, but I can't. You are wanted out of another state. You are an inherent flight risk. And the problem is, any bond I set here now, because of the nature of this case, you're going to have to pony up a majority, if not all, of the bond because you're wanted out of another state. The thing is if you don't have anyone to pony up that money, your mom is a single mother, she's probably working her butt just to make it survive. You think she has enough money to just pony up money to get you out? This is what you need to think about when you start running with the wrong crowd. Because if you ain't got anyone to pony up money to get you out, you're stuck like Chuck until whatever happens with you. And I'll tell you now, more people plead guilty just to get out than they should. Because no one's going to wait 5 months just to fight a case. I don't know what an appropriate amount is, Greg, but it has to be sufficiently high that he's going to go back.
But he's going to go back. Was he going to stay here? He doesn't.
How?
He doesn't have anyone here.
How's he going to get back?
Gets out, calls his mom,
and walk
his
back?
His mom provides transportation.
Have you talked to mom to see if
I'm going to call mom. I was going to see what the bond was, see if she can get him out.
Or call mom. I want to know if she's going to come here and pick him up, and then we'll talk.
Okay, thank you.
I don't want to set people up to fail, but if he's got no ride, if he doesn't have anyone, then,
Okay,
Thank you. Let me know, Greg. And hey, Greg, if she does, I'm willing to go a little bit lower.
Okay, I'll try to get a hold of her. Thank you. No.
That's fine.
Oh, good morning, Mr. Butler.
Good morning. How you doing, sir?
Your lawyer is asking for me to set you a PR bond, but you just picked up another case. Why are you looking at me all confused? You've got a long list of criminal history. You're on bond for a felony unauthorized use of a motor vehicle, and now you've picked up a theft. What happened in the theft, if you don't mind?
It is a retail theft, Your Honor.
Silly.
He was observed, surveillance video, placing merchandise in a black suitcase he obtained from the business and crossed all points of sale without attempting to pay. It was a Target, Your Honor.
The funny thing is that it would only cost $100 to get you out of jail. You now know You have no one in this life that would even pony up $100 to get you.
Sir,
Why?
Just a minute.
You're just, why would we do this?
I was getting close. I had to. Okay.
I don't want you to talk about the case, but Mr. Butler, with all your criminal history, who do you live with?
I live by myself, but somebody is like living there, so I can't even get inside the place while they good. So every time I go through.
I'm not giving you a PR bond so you can just go roam the streets. If he has, like,
I have an address.
some familial place, like a mop, or, you know, uncle, aunt, I'd consider. I'm not letting you out just for you to go roam the streets and up to no more good. No, that's not what we're doing. So if you can figure out something, he's got some family or somewhere where he can go, and I know he's got a bed to stay at, then let's talk. But
Okay.
until that point, no, not to the street. You know, nothing good happens on the streets. And if I let you out, I'm going to have you come testing all the time because I don't want you using anything. Do you understand?
Sure.
Okay, so figure it out and then let's talk, but not to the street.
All right, appreciate it. Thank you.
Yeah. You have the,
I approaching?
I haven't, Judge. No, we're waiting for.
I'm ready when you are.
For my guy? Oh, they got
You
it.
can bring him out next.
Okay.
Good morning, Mr. Living.
How you doing?
Oh my goodness. You were wanted out of the state of Nevada for, number one, robbery with use of a deadly weapon or tear gas, ×2. Burglary while in possession of a firearm or a deadly weapon, ×2 counts. 3, kidnapping, first degree with the use of a deadly weapon or tear gas, ×2. Number 4, conspiracy to commit kidnapping, first degree, ×2 counts. And 5, conspiracy to commit robbery, ×2 counts. Are you waiving formal extradition, sir?
Are you waiving the proceedings that we talked about? You want the 14 days? Yes, Judge, he's waiving.
Okay, good luck, sir.
Thank you, Judge. Does he need to sign it all?
He does. He needs to sign right there.
Okay.
If you need a pen, you got one?
I got one, Judge.
That was living. Living, I'm not done with you. You in Civil War? You want some? Get moving. Okay, thanks,
Thank you.
Ricardo.
Appreciate it. What's that call about the dirt bag? Okay, cool. What happened? Oh,
Lamar Mesa. Is discovery complete on this house? State.
Your Honor, just one moment. There was surveillance video that we just put that, it's not gonna see. Body worn camera, dash camera, and surveillance video, I can prove that.
Please, please get on it. This case is 1,256 days old. If you ever take off on me again, I'm gonna make your bond so high, you're gonna have teeth falling out. Do you understand? As of today, you will get an ankle monitor, so I know where you are at all times. I'm giving you 30 days from today to make a decision on what to do in this case. We will either set you for trial or you must accept the plea bargain from the state in 30 days. And like I said, you ever take off on me again, your bond will reach the clouds. Do you understand? Where is this that, is this a co-defendant of the other one? I mean, are they the same day for real? Remember the one we had earlier today? Ms. Okafor.
Greg.
Oh.
Greg.
What was that? Defendant, what was that one? Nieves, was that?
1269.
Oh.
This one, it's not a code of conduct.
Ah,
Yeah, I'm ready.
so where's this one from? Is this Target? Is this?
This is from J.C. Penney.
I'm ordering you as a condition of your bond not to go to any J.C. Penney for any reason. Do not pick up a new case. And I'm going to tell you now, Mr. Lamar Mesa, I'm going to do everything in my power to protect my community at all costs. If I find that you're a danger to my community, I only have one place for you. Okay?
All right, 30
Okay,
days?
30 days.
Okay, thank you.
Do not leave until you sign our bond conditions. Don't worry about filing it because I'm having it monitored, so we can do it with Fleischer. All right.
It's a Monday.
Client, told me that he has a VAWA case pending,
Is a what?
VAWA case pending in immigration process.
Okay.
So we have an offer. I asked, are you ready to plea or not? He's kind of like iffy about it because he doesn't know how that's gonna affect,
We need
you
to,
know. Can we get a short recess just so he can get an appointment with his immigration attorney and see if, I mean, we don't have a lot of options besides plea or trial at this point.
and I'm gonna tell you now, I'm a time served on a second. Yeah, just so you know.
I
Okay,
told him because at probation, ICE might pick him up in one of his check-ins and time serve is ideal for him in his situation, but you know, I think that we can just get cases dismissed left and
yeah,
right.
we don't, so, okay, I'll give you a week.
Yeah,
Okay.
and I'm gonna tell him just check in with the immigration attorney by next week, and if not, I mean,
So,
trial, I mean, that's pretty much it.
Rick,
Senor Ramirez? He's a Spanish speaker judge.
so do I.
Oh, yeah, I forgot about that.
Tu caso ya tiene 200 días. ¿Es tiempo para tomar una oferta o poner tu caso en jurado con juicio? Tú tienes una semana para hablar con un abogado de inmigración. Yo no te doy más tiempo después de una semana. ¿Me entiendes? Si no lo tienes hecho, no me importa. Vamos a ir adelante. ¿Entiendes? Ok, una semana.
Okay, all right. Ahorita hablamos. Thank you, Judge. Thank you, Judge.
One case.